An employment relationship is formed when parties exchange promises about duties, wages, hours, and benefits. Employers have policies and forms that define the arrangement, but legislatures and courts have added terms to it. At-will employment is the relationship predominantly used by American businesses, and governments use it liberally as well. In its pure form, it means that if the parties do not specify the duration of employment, and most do not, either party may terminate the employment at any time for any reason. Supporters claim that the relationship upholds freedom of contract and fairly balances the interest of employers and employees because either may sever the relationship. But critics point out that many workers need their jobs more than their employers need them, so at-will employment opens the door to abuse. It also subjects families to uncertainty and hardship based on employers' whims. An example of these effects, lawmakers and courts have carved out exceptions to at-will employment that make it unlawful for an employer to take adverse action against an employee for a specific bad reason. The civil rights laws are the most well-known example. As a result of these exceptions, at-will employment now means something different. If the parties do not specify the duration of employment, either party may terminate it at any time for any lawful reason. From a manager's perspective, this means that even at-will employees have many rights that cannot be violated. The reality is, in the public sector, many employees do not serve at will. Legislatures and courts have added conditions to these arrangements as well. The Supreme Court has ruled that when a law, rule, or understanding creates an expectation of continued employment in a government job, then employees possess a constitutionally protected property interest that cannot be taken away without due process. The Supreme Court has also ruled that when a public employer takes adverse action against an employee, it is a state's action, so federal and state constitutional protections apply. As a result, employees who exercise freedom of speech or freedom of association or assert the right to privacy at work cannot be punished if their conduct falls within the ambient of one of these constitutional protections.